follows the text and the outline contained in our book, which is sold by Juris Publishers. They're a great organization out of New York. And I mention it only because there are lots and lots of answers in here that I think might benefit you. So go ahead and head to our website if you have questions. I just want to also say that on our website we have the ability for you to answer any question of any nature relating to subrogation. I get some bizarre questions, but we hopefully answer those within the hour. We have a lawyer who will respond to your question in any jurisdiction, and that means anywhere in North America, and we subrogate pretty much all throughout the world. So with regard to this webinar, I just want to say that this is the latest in a series of webinars we have done back in 2012. I did a grand flyover from 35,000 feet, an overview of auto subrogation in the United States. And we took a poll during that webinar and asked for the top 10 states that people wanted to have addressed. And we have addressed those in the order that they were listed. And those states were Texas, Florida, California, New York, Illinois, and Michigan so far. And today we're going to be on, obviously, Colorado. California didn't make or made the top 10, but they were number 3. So if you have questions about any of those other states, you can go to our website and actually attend and replay the webinars that we had on those states. States like New York, California can be very confusing, and I think these webinars will be very helpful. Coming up, we have the last states left in the top 10 for our auto webinar series. That includes New Jersey, which is very complicated, Arizona, which is in flux, and Louisiana. And we have a branch office of our firm in New Orleans, and Jim Buselman will probably be presenting that webinar as well. So let's talk just briefly about why it is that auto subrogation is critical and why it is that it is so difficult. If you think about it, and I do a lot of subrogation in a lot of different areas, and this is my 33rd year, it's amazed to say, but we as an industry have several things are combined to make auto subrogation, in my opinion, one of the, if not the most challenging area of subrogation. It's the perfect storm. You have 51 jurisdictions with 52 bodies of law, including federal law. You have a mixture of fault and no-fault states, which mix about as well as oil and water and cause a lot of confusion. It's a moving target. Every day, law changes. Just like the weather, we have to deal with new law that can dramatically affect our subrogation rights, and we'll see in Colorado that this has happened in the recent past. The number one question we have from our website and we receive from some of the listservs has to do with extraterritorial subrogation, conflicts of laws. Cars are designed to travel. Therefore, they travel between states. And you have cars garaged in Minnesota with owners who may live in Texas part of the year who get injured and get involved in an accident in Florida. And then you have the question of which state governs your subrogation rights. We will get into this today with regard to Colorado law, but obviously this brings into the question of conflicts of laws and makes auto subrogation even more difficult than property or workers' comp or many other areas. And I think one of the things that makes it more difficult for us too is that this area of subrogation litigation is targeted for anti-subrogation efforts more than any other. I don't have time in today's webinar to go into my opinions on some of the efforts that are made and the nonsensical anti-subrogation efforts that are made in the area of auto when they do nothing but help keep premiums down for insurers, but that's for another day and another time. So this webinar is 60 minutes. I do try to keep it to 60 minutes, although we have a lot of things to cover. During this webinar, we will have a trivia question, and the winner of that trivia question will receive a complimentary book of our complimentary copy of our auto subrogation book, which I previously showed. And I will ask you to email Jamie Breen. You can email in on the the feature that allows you to email in, or you can just send an email to jbreen@mwl-law.com, and I will present that trivia question, and y'all can get out your smartphones about 2/3 of the way through the webinar. All right, so let's get started. Effective auto subrogation is critical because think of the number of cars we have in the country. It's approaching 300 million cars, 23 million licensed drivers. There's more than 7 million auto accidents in the U.S. annually with a huge financial toll. People are injured, people are killed. 10 people will die today on the roads during this webinar, and many of those will find their way to you in the way of a claim and a potential subrogation file. Auto property damage annually is $35 billion, which presents, in almost all cases, subrogation potential. These are small files that force us to face the odds and be cost-effective in our efforts, because with a $2,000, $3,000, $8,000 collision subrogation claim, we can't afford to outspend the other party. So we have to be smart, and that's what this is about. It is said that spectacular achievements are always preceded by unspectacular preparation, and that is what this webinar is all about. And hopefully you won't say it was unspectacular when it was over with, but receiving a big check when you can successfully recover on an auto subrogation file you otherwise wouldn't have because of something you heard here, that is spectacular. Let's get into Colorado. And with regard to Colorado, let's talk about personal auto coverage. As of 2010, Colorado had 3,107,000 drivers, and 26 to 34% of them are uninsured, so it's way above the national average. Liability insurance is required under Colorado law, and such insurance must be in at least the following amounts. For liability insurance, $25,000 per person, $50,000 for all persons in any one accident. Liability for property damage of $15,000, and the minimum required liability for a truck exceeding 16,000 pounds gross vehicle weight is $100,000 per person, $300,000 per occurrence, and $50,000 for property damage. Personal injury protection. Thankfully, Nofault was repealed in Colorado in 2003. We'll talk about that in a moment. So we don't have to worry about PIP. We don't have to worry about tort prescriptions and limits on tort liability. Instead, PIP payments have transformed into Medpay payments, and Medpay coverage of $5,000 must be offered by the carrier, but it can be rejected in writing. Uninsured, underinsured motorist coverage, it covers medical and other expenses when the insured is hit by a third party without insurance or without adequate coverage, and carriers are required to offer coverage in the same amount as the bodily injury liability limit selected by the insured, but and coverage can be waived in writing. So the insured can select limits starting at $25.50, the same as the minimum limits policy, and all the way up as high as your liability limits go. Uninsured motorist property damage coverage, however, is an optional automobile insurance coverage in Colorado, and it can be rejected. It's not available, however, if collision coverage is selected, and it's only available with the selection of uninsured, underinsured motorist bodily injury coverage. You can't have it solo. Collision coverage, well, this provides coverage for the damage to the insured's vehicle, obviously, if it collides with another vehicle or another object, and this coverage is not required by law, although obviously some banks who are lending for new and used automobiles may require it. Colorado subrogation generally. Colorado is a fairly good state, subject to some recent changes that were made, and we're going to get into those because Colorado has become a little bit more complicated over the past 5 years. But Colorado recognizes equitable subrogation, subrogation which occurs simply by the fact that an insurer made payment for its insured. And under the doctrine of equitable subrogation, when an insurer is paid its insured for a loss covered by a third party, or caused by a third party rather, it may seek recovery from a third party. However, such an equitable subrogation claim anywhere in the country is usually subject to equitable defenses such as made whole, common fund, and others. Colorado also allows contractual subrogation, and policies in Colorado contain language such as, quote unquote, if we pay under this policy, we are entitled to all rights of recovery of the person to whom payment was made against another. That person must sign and deliver to us any legal papers related to that recovery, do whatever else is necessary to help us exercise those rights, and do nothing after loss to harm our rights. It further says, when we pay damages under this policy to a person who also collects from another, the amount collected from the other shall be repaid to us to the extent of our payment. And this becomes relevant later on as we get to Medpay Subro and the situation there. But in 2010, the Supreme Court of Colorado made a distinction between contractual subrogation and equitable subrogation and enacted a new statute, Section 10-1-135, that we will get into in some detail. Now, the purposes of subrogation, obviously, to hold tortfeasor responsible for the losses, to prevent double recovery, and to hold down insurance premiums, actually bears out in Colorado, which, of course, in 2003 was toward the bottom of the states in terms of average auto insurance premiums, approaching $2,000 average. And after the repeal of Nofault, it is jettisoned up to number 26. The national average is $1,311, and Colorado is currently at $1,245, right in the center of the 50 states. So let's get into Medpay subrogation. Medpay subrogation is going to be divided as in AD and BC, how time is divided. In history, Medpay subrogation is divided policies issued before 1109 and policies issued after 1109. For policies issued before January 1, 2009, Medpay subrogation reimbursement clauses are generally enforced. It appears that Colorado, for these policies, will allow a subrogation action under the doctrine of equitable subrogation, even where it has no reimbursement or subrogation language, and they will also enforce contractual subrogation. But for most policies and most of our claims now, unless you have older claims, for policies issued, delivered, or renewed after January 1, 2009, Colorado has amended Section 10-4-635, which provides that an insurer providing Medpay benefits will not have a right of recovery against an owner, user, or operator of a motor vehicle, or against any person or organization responsible for causing the accidents for any Medpay benefits paid. An insurer shall not have a direct cause of action against an alleged tortfeasor for benefits paid under Medpay coverage. All right, that's important. The amended statute says that you will not have a direct cause of action in subrogation against an alleged tortfeasor. Okay, we have to live with that. For some reason, the Colorado legislature saw fit to restrain subrogation, even though the benefits help keep down the premiums. And the rest of 10-4-635 leads to what is a rather heated debate among Colorado lawyers. Even though we can't pursue the third-party tortfeasor directly from Medpay, can we proceed with a possible contractual reimbursement claim? If you remember the language that I read on the policy, it says that one of the clauses provides for reimbursement. It says if you receive money from a third party, you must repay to us the benefits we paid. And most of our policies still contain that language. Section 10-4-635 says that nothing in this subsection shall be construed to, quote, afford an insurer a cause of action against a person to whom or for whom the Medpay coverage benefits specified in this section were paid, except in a case where the benefits were paid by reason of fraud. So what we have is a statute which says we can't sue the third party directly, and it says that nothing in this statute creates or affords an insurer a cause of action against a person to whom or for whom the Medpay benefits were paid, except in the case of reason or fraud, or paid by reason of fraud. So there is no direct subrogation of Medpay benefits, but is there a contractual right of reimbursement? Well, that's hotly debated. I tend to, right now there is no case that specifically comes out and says you cannot, but there are a lot of considerations. Nothing in the statute specifically negates or eliminates any contractual duty of reimbursement the insured owes the carrier pursuant to the terms of the policy. If this issue is addressed by the Colorado Court of Appeals or the Colorado Supreme Court, it is entirely possible they may declare that such a reimbursement action is not allowed. But nothing in the statute right now authorizes or prevents a contractual reimbursement action. Therefore, although it appears that the legislature was attempting to put limits on reimbursement recoveries altogether, the language of the bill appears to be insufficient to accomplish that goal. So what I tell my clients is this. The bad faith climate is not good for carriers in Colorado. I have, on many occasions, advised plaintiffs' attorneys who were telling me that we're not subrogated to Medpay benefits. I told them over the phone that the statute does not prohibit me from enforcing my policy reimbursement language. Some have disagreed and some have paid. But because the bad faith climate is not good in Colorado, and the sense is that pursuing a contractual reimbursement claim would likely generate some debate as to whether or not that's allowed, many carriers are not interested in taking that risk over a $5,000 Medpay recovery. But having said that, even if a carrier is successful in seeking reimbursement of Medpay benefits, we're going to be looking in a little while at a statute, section 10-1-135, which applies the made-whole doctrine and the common fund doctrine to all subrogation, including Medpay reimbursement claims. So the last thing I want to mention is that the third party is prohibited by 10-1-135 from including Medpay payor, the name of the Medpay carrier, on a settlement check. So they're prohibited from including a payor of benefits as a co-payee on a check or draft issued in settlement. And oftentimes that was our leverage to get some sort of negotiation on reimbursement of the Medpay benefits. So Colorado has gone from being a pretty favorable Medpay subrogation state to being a very, very difficult state in which to recover Medpay benefits. PIP subrogation, this may be the easiest slide we have. Nofault, of course, was originally introduced in 1973, and when PIP coverage was mandatory and it provided coverage for medical and rehabilitation expenses without regard to fault, there were no subrogation rights at all because tort actions were limited. So for vestigial policies issued prior to July 1, 2003, when Nofault was repealed, an insurance carrier is not allowed to subrogate a payment of PIP benefits made to the insured unless the accident involves a private passenger motor vehicle and a non-private passenger motor vehicle. I just can't wait until all the no-fault states go away, and we don't have to deal with this nonsense. Colorado Court of Appeals decision has held that Section 10-4-713 of the old No-Fault Act only allows the insurer of a private passenger motor vehicle to bring a subrogation act against a non-private passenger motor vehicle. But we're not going to see too many of those now that 12 years have passed since the repeal, so we don't have to worry about that. Medpay has replaced PIP benefits, and as I've indicated previously, premiums have dropped. Uninsured motorist and underinsured motorist subrogation. This is another area that used to be fairly straightforward and has gotten a little more difficult as of January 1, 2008. The purpose, of course, of subrogation is to hold down premiums. It's an incentive to obtain liability insurance. The subrogation of the uninsured driver and it prevents a double recovery. But The newly revised Section 10-4-609, effective January 1 of 2008, addresses UM and UIM claims, and it closes several loopholes that prevented consumers from receiving the full benefits that they thought they were buying when purchasing UM and UIM coverage in Colorado. So every uninsured and or underinsured policy that's issued on or after January 1, 2008 is affected by this change, and it changes it in two important ways. Before 1/1/2008, the insurance company could offset the payments paid by the at-fault driver's insurance company against the amount available under their own UM policy. And prior to January 1, 2008, insurance companies were able to include anti-stacking language in their UM coverages that would prevent those who pay for multiple policies to add those policies together in order to maximize coverage. So the new law, after it says 2007, I guess it's really, technically that's correct, after 1/1/2008, this new law makes UM coverage stack on top of the total amount of insurance available from the at-fault driver. For example, if you bought $50,000 of UM coverage, the entire $50,000 is available on top of the insurance available from the at-fault driver. So that's a significant change in terms of UM and UIM coverage. Now, in terms of UM and UIM subrogation, a UM carrier in Colorado can enforce its rights of subrogation against the uninsured motorist. This hasn't changed. It's not prohibited by 10-4-609. Part of the reason is that UM coverage is optional, and 10-4-609 does not expressly prohibit it, so we can do it. However, in a few slides, we're going to be getting into the Mayhold Doctrine, Section 10-1-135, and it also applies to uninsured motorist subrogation. 10-1-135 is an anti-subrogation enactment which not only applies the Mayhold Doctrine to all health insurance subrogation, auto Medpay, auto medical subrogation, but also legislates the Common Fund Doctrine. This is the doctrine that says that if you successfully are reimbursed your payments, you have to pay a pro rata share of attorney's fees for the attorney who did the heavy lifting, who was the laboring or in the underlying tort or settlement negotiations. So if a carrier is successful, they have to pay a proportionate share of the insured's attorney's fees. And this applies to any third-party recovery by an insured, whether through settlement or judgment. Now, for underinsured motorist subrogation, policies, of course, have consent to settle clauses. You have to provide prior written notice of a settlement to the carrier in order to give them the opportunity to make a decision. An insured would jeopardize its coverage, his or her coverage, if he settled and released the uninsured or underinsured driver without first obtaining permission of us, the UM/UIM carrier. If the insured signs a release and destroys our right of subrogation, this could violate exclusions in the policy. So when we are faced with a request by the insured for permission to settle the third-party case, we have to do in Colorado what we have to do in most states. We have to make an informed decision. We must determine whether we're going to seek subrogation. We can look at the potential assets, do a quick asset search, knowing that if we proceed against the UM carrier, against the UM driver, we're probably going to get a fast judgment, which may or may not be worth the paper it's written on. And if we proceed against the UIM, the underinsured motorist driver, we're going to have the third-party carrier probably, in most cases, providing a defense of the case, which is going to make it difficult, except in cases of clear liability, to recover more than the policy limits. In any event, if we're not willing to advance the amount of the settlement by making a substituted payment, in other words, there's $25,000 policy limits, the plaintiff wants to settle, we say no, we think the third-party tortfeasor has some vacation homes and won the lottery recently, so we want to go after him. We probably need to make a substituted payment to the insured in the amount of the third-party limits, take an assignment, and then we can proceed against the tortfeasor. So that's UM/UIM claims have changed, and subrogation has changed because it's now subject to the made whole doctrine, which we're going to discuss a little further here in a few minutes. So collision and property subrogation, of course, this makes up the bulk of auto subrogation in most cases. Claims can be small, they can be large, but by and large, Colorado allows for the subrogation of property damage to a vehicle as the result of an accident. And the proper measure of damages in a case involving damage to an automobile is the difference in the market value before and after the collision. They're in the majority on this. If the vehicle is repairable, the plaintiff is entitled to the reasonable costs of repair together with the reasonable diminution in value, the decrease in market value to the property as repaired. Nobody wants a car that's been damaged in an accident if they can obtain another vehicle for the same amount that hasn't been in an accident. It's just common sense, and it's part of the free market system. So those are the measures of damages. Now, an owner may also recover for loss of use of a vehicle, and this recovery right can be in an amount of the reasonable value, rental value for a length of time reasonably required for the repair. So if an owner proves what length of time is reasonable for repair, and that can be done through his own testimony, he doesn't have to have an expert or a rental car manager or somebody appear on a stand, but all he has to do is prove what a length of time is reasonable for the repair. He need not actually have his property repaired in order to recover loss of use damages. So damages for loss of use could also take into consideration in Colorado loss of net profits, meaning net earnings or the excess of returns over expenditures as a result of the loss of use of, say, a taxi cab or a small business that has a vehicle that's a truck that is the only vehicle it can use in its operations. So these are things that not only do we need to be aware of as liability carriers, but these are things that we can use to our advantage when subrogating collision and property claims in Colorado by threatening the possible claim of the insured for such loss of use. And this can be successfully done by simply saying, by the way, you know, this insured is happy as a clam. He's getting his truck fixed. But if he were to bring a claim, he would have a claim for his loss of profits, the loss of net profits and the net earnings or the excess returns over expenditures. And do you really want that? Why don't you pay me 100% of my collision claim and let's get this thing over and done with. Now, one of the things you have to be aware of is that in these situations where the insured has the loss earnings or other uninsured losses, is you want to get with the insured and make sure that they aren't making a claim because you don't want to have a made whole issue. You don't want to settle a claim if they have claims that are still outstanding. And again, we'll get to made whole in just a minute. On a related issue here, and this is, we're going to be doing an article that's going to be in Claims Journal online. If you Google my name in Claims Journal sometime, we have a lot of articles that are posted on the national website for Claims Journal on a variety of subjects. We're having one that's going to come up here shortly called Recovery of Sales Tax in Total Loss Situations, first party and third party. And it's going to be an article about the overview of the state of the obligation of insurers, both first party and third party, to pay sales tax in the case of a total loss situation. So if a car is totaled and you pay the value of the car and the insured goes out to buy a new car and has to, in addition to the price of the car, pay sales tax, he's been damaged beyond what he's been paid. And so the question becomes, in first party claims, does the insurer owe sales tax? And in third party claims, does the tortfeasor's liability carrier owe for sales tax in total loss situations? This will be an interesting article, and it will have a chart to accompany it. And the chart, Jamie is listening, and she would know, but the chart is either on our website now or it will be on as soon as this article hits Claims Journal. And I think that it is set to be on the Claims Journal shortly here in a matter of days. Anyway, Jamie just peeked around the corner and gave me the thumbs up. Jamie, did you say it's on? Oh, she says it's already on the website. So you can go to the website and see how this issue is handled in all 50 states. So that's just a topic that we bring up. But in Colorado, that's something that you'll want to look into as well. Now, an issue that comes up quite often is, well, what happens if we get to the tortfeasor with our subrogation demand and they tell us, well, so sad, too bad, we've already received a release from the insured. We paid them $250 for their deductible or whatever, and we've released the claim. These claims fall into two different categories. In Colorado, it can be if the tortfeasor has no knowledge of the subrogation interest, or the tortfeasor has knowledge of the subrogation interest. Generally, a release by an insured of a third-party tortfeasor who is without knowledge of an insurer's rights of subrogation, i.e., have we put them on notice, is a bar to an insurer's claim to subrogation. However, if that same tortfeasor had knowledge of our subrogation rights, and this is where prompt notice comes into play, and enters into a settlement with the insured anyway, thinking it might absolve them from having to make any subrogation payments, then we, the subrogated carrier, can still pursue the tortfeasor. Our subrogation is intact. And in fact, there is some law in Colorado to the effect that the third-party carrier may have a duty to place a lien holder's name on a check as well. So res judicata is Latin for the thing having been adjudicated. This is a situation that comes into play, say, when your insured goes out and files a small claims court action to recover for damage to an iPod or a laptop computer that was in the car when it was smashed into. And let's say judgment is against the insured in that claim. And so now there's a judgment out there, plaintiff insured versus tortfeasor, and the tortfeasor won. Even though it was only for damage to a silly laptop and we have a huge property loss or Medpay claim or what have you, res judicata may bar subrogation. So when an entity takes an assignment from the insured and the third party has notice of the assignment, the payment to the assignor does not discharge the liability, but res judicata might. So if the defendant defends that case and has knowledge of our subrogation interest, and again, notice being so important, then that judgment will not bar our next subrogation lawsuit, which we will file and claim that res judicata does not apply because they had knowledge of our subrogation interest. Now, quite often we get these, and this happens a lot in Illinois, but if you have a Colorado insured who's driving in Illinois and you have some of these non-standard carriers who will send you a check for 40% of a clear liability collision loss and say, here, take it or leave it, and it has language that if this is executed, it's full satisfaction of any and all claims, blah, blah, blah. This sort of release by, or this sort of partial payment effort is known as accord and satisfaction. And if a tortfeasor or an insurer sends you a check, Colorado actually has a statute that deals with that. In many states, in the case of a check offered as full payment for a disputed amount, generally a creditor cannot avoid the consequences. We cannot avoid the consequences of accepting the accord. Accord is the cashing of the check. By declaring that we can avoid the consequences by declaring that we don't agree to the condition attached by the debtor on the check, i.e., this is in full satisfaction. So in many states, that's the law. Colorado has passed Section 4-3-311, which divides the world into two categories, liquidated and unliquidated claims. So if a claim is discharged, if you cash a check for $4,000 on a $10,000 collision damage claim and the check says this is payment in full or some other accord and satisfaction language, the claim is discharged if it's an unliquidated disputed amount and there's conspicuous writing regarding full satisfaction of the debt, i.e., this is full satisfaction of the claim or some such thing wrote on the check, and there is a bona fide dispute as to the amount of the loss. In other words, an unliquidated claim means, well, it can mean in a $10,000 collision damage case, they might claim that, well, they could have gotten it done with Uncle Charlie for $19 an hour, and the claim, it would have cost only $2,900 to fix the car. That's a bona fide dispute, and that claim is unliquidated because we haven't proven it up. But the claim is not discharged if the debtor doesn't know, if we, the subrogated carrier, don't know that the check is tendered as full satisfaction, and there is no paid in full language included. That means that the letter that the check came in can't say, by the way, if you sign this check, we're done. I never want to hear from you again. If they send a $4,000 check and there's no language anywhere, including emails, phone calls, then the claim is not discharged. What I find happening a lot is situations where there is no language. They accept $4,000 on a $10,000 loss, and then we get the claim to recover the additional $6,000. I suddenly start hearing, well, I spoke with Rebecca Smith on the phone, and I told her I would send her $4,000 if this was in full satisfaction. And Rebecca's like shrugging her shoulders. I never talked to this guy. So that does get a little complicated. But the bottom line is, if you get these partial checks, check with us. We can talk about the surrounding facts and circumstances and whether or not it would actually bar your claim for accepting a partial payment. So now we get to the bane of subrogation in many states, and especially in Colorado. The made-whole doctrine has been supplanted in Colorado with regard to auto subrogation by Section 10-1-135. And in pertinent part, it says reimbursement or subrogation pursuant to provision in an insurance policy, contract, or benefit plan is permitted only if the injured party has first been fully compensated for all damages arising out of the claim. Any provision in a policy, contract, or benefit plan that allows or requires reimbursement or subrogation in circumstances in which the injured party has not been made whole is void and against public policy. Now, it doesn't take Einstein to conclude that obviously the trial lawyers are hard at work in most states in their anti-subrogation efforts, and they were hard at work in Colorado in 2010 when Section 10-1-135 was passed. This was first introduced in Colorado for subrogation for many, many years. Made whole only applied to uninsured motorist subrogation. In other words, the insured had to be fully made whole before you could recover from the uninsured motorist. That actually had the effect of squelching subrogation, because unless you had some affirmative acknowledgement that the insured was made whole, it just wasn't worth it to go against some deadbeat who you may or may not ever see any money from or get, $12.50 payments each month. So for many years, it only applied to subrogation. And prior to 2010, auto subrogation was governed by common law. Well, what does that mean? That means that for many years up to 2010, Colorado courts made no direct pronouncements regarding made whole with regard to subrogation, and the policy itself could proscribe or contract around the requirement for the insured to be made whole. And it was quite easy to do. So for many years, Colorado didn't have to concern itself with made whole. But along came Section 10-1-135 on August 11, 2010, and this is a rather comprehensive piece of legislation which codifies common law principles regarding subrogation claims, including the made whole doctrine and, as we'll see, the common fund doctrine. It applies to all cases pending recovery as of that date. Section 10-1-135 is meant to ensure that each insured recovers full compensation for bodily injury caused by the tort of a third party, and that this compensation is not diminished by repayment, reimbursement, or subrogation rights. Again, this has trial lawyers' fingerprints all over it, and the legislature was complicit with them and basically abandoned the favorable effects that subrogation has for the residents and drivers of Colorado. So looking at 10.1.135, it says that reimbursement will not be permitted when the injured party will not be fully compensated. It says that this is in the best interest of the citizens of the state to ensure that each injured party recovers full compensation for bodily injury, even though there's really no definition of when that happens. Section 10.1.135 limits the ability of a quote-unquote payer of benefits, which is us as an auto carrier, to subrogate or seek reimbursement of benefits in any third-party claim, and applies to any HMO, any auto insurer, any health plan, or any provider of health care benefits, which of course includes an auto insurance carrier. Now 10.1.135 permits subrogation only if the injured party has been fully compensated, but again, it doesn't tell us what that means. But what it does do is it gives us a set of presumptions. And for that, I suppose we should be grateful. Fully compensated isn't defined, but if the insured settles for less than the third-party limits, including UIM benefits, there's a rebuttable presumption that the insured is made whole. These are things that we have to really sink our teeth into in subrogation in Colorado. We have to use these presumptions to our advantage, citing cases that set forth the presumptions, citing the statute language itself. Another presumption is that if the insured settles for the exact policy limits, there's a rebuttable presumption that the insured was not made whole. So if the settlement is for less than policy limits, presumption made whole. Exact policy limits, presumption is the insured is not made whole. If there is a judgment, there is a rebuttable presumption subject to hearing by the court to determine otherwise that the insured has in fact been made whole. Now, if the insured is made whole, subrogation is allowed. If the insured claims it's not made whole, the statute provides that the dispute must be resolved by arbitration. So if there are any disputes with regard to the made whole issue, they must be resolved according to the terms of 10.1.135. If the insured feels he's not made whole, he has to notify the subrogated carrier within 60 days of receipt of the recovery. Notice must include, and this is very specific, these are things we can use to our advantage. Sorry, Mr. Trial Lawyer, you didn't comply with 10.1.135. The notice has to include the total amount of the recovery, the coverage limits applicable to any available policy, and the amount of costs charged to the insured. If we want to dispute that the insured has not been made whole, the dispute must be resolved by arbitration. We must request arbitration no later than 60 days, so 60 days is the key here, 60 days after receipt of notice from the insured. In that event, the insured and us, the carrier, have to jointly choose an arbitrator to resolve the dispute, have a list of arbitrators that you can rely on that aren't former trial lawyers who simply lost their practice for some reason and decided to become arbitrators. If you and the insured or his lawyer cannot agree, the dispute is resolved by a panel of 3 arbitrators, one selected by you, one selected by the insured, and one selected by the first 2 arbitrators. And another troubling provision of 10-1-135 is that the subrogated carrier is prohibited, and this is important, from pursuing any subrogation directly against a third party unless within 60 days of the running of the applicable statute of limitations, the insured has not pursued a claim against the third party. So diarying is important here. 60 days, again, being the key. So Section 10.1.135 will not affect current coordination of benefits procedures. It will not affect the application of Colorado's collateral source rule, which we'll discuss in a second, and it does not apply to workers' compensation rights. But it is a new statute with very little case law interpreting it. There are many questions which surround its application, and that's where your advocacy hat comes into play. You've got to argue your case and your interpretation for the statute. And by the way, it applies only to recoveries made after August 11th of 2010. So now that we've discussed made whole, 10-1-135 also does something else. The trial lawyers also said we want to be paid. So prior to 10-1-135, Colorado recognized the common law common fund doctrine. Of course, this is, as we know, the equitable doctrine that those who benefit from litigation have to pay for it. So if the plaintiff's attorney, the insured's attorney, does all the work, is the laboring oar in the third-party litigation, recovers money and pays you back, you have to pay him a pro rata share of his fees and costs. However, in 1996, the Court of Appeals refused to apply this doctrine, the common fund doctrine, where the insured did not give the insurer an opportunity to participate in settlement negotiations, where the insurer expressed an intent to pursue its claim independently in arbitration, and where the insured expressed no intention to share in the funds generated by an insured suit. So there was a defense to the equitable common fund doctrine. However, August 11, 2010, Section 10-1-135 codified several common law principles governing subrogation claims, including the common fund doctrine. So what it says is it not only applies the made whole doctrine, but also codifies the common fund doctrine and makes carriers who successfully seek reimbursement responsible for a proportionate share of the insured's attorney's fees. It applies to any case by settlement or judgment, and the language is when reimbursement or subrogation is allowed, the amount recovered by the subrogated carrier cannot exceed the amount actually paid by the carrier or benefits paid by a capitated plan. And just briefly, this doesn't apply to most of us, but a capitated plan pays a specific amount periodically to a health provider for a group of specified health services. Now, I mentioned that because I had a question about that even before the webinar began. Note that there is a federal court rule, and this is what I want you to remember, O'Donnell versus Sullivan. Even after this statute, there's a federal court decision which says that the common fund doctrine can be altered by contract. Quote unquote, the court said, the common fund doctrine does not apply to this agreement, and the carrier shall not be responsible for payment of the insured's attorney's fees or court costs of any monies owing under this agreement. They held that that language contained in the policy, again, it reads, the common fund doctrine does not apply to this agreement, and carrier shall not be responsible for the payment of insured's attorney's fees or court costs. That language was sufficient to make the common fund doctrine inapplicable. Cite that case, because I'm not sure how the courts are going to deal with the irreconcilable conflict, but it certainly is in our favor, and we should take advantage of it. I'm going to talk about the economic loss doctrine, but before I do that, Jamie just stuck her head in here and reminded me that we have the trivia question. So I'm going to give you the trivia question now, and then you can email Jamie with the answer. And here's the question. John Henry Holliday, also known as Doc Holliday. Doc Holliday's storied and tumultuous life led him to a town in Colorado where he succumbed to tuberculosis and died at a hotel on November 8, 1887. Shown in the movie Tombstone, starring Kurt Russell, what is the name of the town that Doc Holliday died in? Email the answer to that question to Jamie, and the first one with the correct answer will receive a copy of the auto subrogation book. And actually, I think the publisher has made that book the most expensive. I don't know how much it is, but it's like $400 or something. So that's a kind of a nice trivia prize. All right, while you're all not paying attention now, I'll talk about the economic loss doctrine. Real quick, economic loss doctrine, this is, you've got a car that is sitting in the driveway and electrical fire occurs and the car burns up and you want to sue the manufacturer. In most states, a party suffering only property damage to a vehicle as a result of a defect or failure may recover damages for that harm from the manufacturer based upon a contractual claim and not on a tort theory. So what that means is you generally cannot sue the manufacturer for damage. However, Colorado is in the minority, and this is to be remembered. Motorhome going up Pikes Peak, going over the Continental Divide, burns up, and for some reason I have a lot of motorhome burn cases that occur in those areas because of the steep slopes and whatnot. You can pursue a product liability action against the manufacturer. That's something you should keep in mind. Deductible reimbursement. Now, there is no applicable statute, code, or provision or case law in Colorado which deals with when and under what circumstances you have to reimburse a deductible or a portion of a deductible or none of a deductible if you're successful in subrogation. I do want to make a note, though, because I had a pre-webinar question that said, well, but you have, if they follow the made whole doctrine, don't you have to reimburse the deductible or else the insured isn't made whole? And I just want to briefly say that I think we often assume that if a state employs or recognizes the made whole doctrine, then the insured must be totally reimbursed for its out-of-pocket deductible and any uninsured losses before a carrier can subrogate. But unfortunately, that is oversimplistic, and that is not, there may be, I think, 2 states that apply the made whole doctrine to deductible reimbursement, but that is not only erroneous, but it results in reduced subrogation recoveries for us around the country. The obligation of an insured to reimburse some of its deductible has very little, if anything, to do with the made whole doctrine, and there's no support for the proposition that it has anything to do with the deductible reimbursement in Colorado. There are some articles we have on our website, and there's a deductible reimbursement chart that has a preamble that explains in much more detail why the made whole doctrine does not apply to prevent you from subrogating, even if the insured has not recovered its deductible, in states where there is no applicable statute, code, or case law. Otherwise, you've got to follow the regulation that the state has. Collateral source rule, I just want to hit on this briefly. This is the rule that excludes from evidence at trial the amounts paid by a collateral source. Colorado has the statute enacted also in 2010. Trial lawyers were busy in 2010. It modifies the common law rule to limit circumstances under which a plaintiff may receive a double recovery. It requires a reduction of tort damage awards by the amount the plaintiff, quote, has been or will be wholly or partially indemnified or compensated for his loss by any other person, corporation, insurance company, or fund. So essentially, this statute modifies the common law collateral source rule to limit the circumstances under which a plaintiff may receive double compensation. The underlying, or the portion of the statute that's most important, constitutes a contractual exception provision which states that a, quote, verdict shall not be reduced by the amount by which the plaintiff has been or will be wholly or partially indemnified or compensated by a benefit paid as a result of a contract entered into and paid for by the plaintiff. So what that means is subrogation. It's written cryptically. I think it was written cryptically on purpose, but it basically says that there's an exception for subrogation. Now, comparative fault. This is important because Colorado does have modified comparative fault, and it's only one of 11 states that has the 50% bar rule. Why is that important? Because experienced liability claims handlers understand that juries are not, always the smartest and swiftest, and they will often just say, well, let's just split the baby and go home. We'll put 50% fault on both parties. When that happens, of course, the plaintiff recovers zero. However, because it's comparative fault, if the plaintiff is 30% at fault and has $10,000 in damages, the plaintiff can recover all of his damages except for that portion that is attributable to his fault. Sudden emergency doctrine. This is interesting in Colorado because it comes up in the context of the example I gave is a wheel comes off a trailer on a freeway, causes the car behind the trailer to swerve, and the defendant must exercise judgment and prudence required of one unexpectedly confronted with imminent peril. This doctrine was abolished in 2013, and that's really all you need to know about it. It includes cases of, grandpa has a seizure or a stroke and drives off the road and through someone's house, which actually happened to my sister this summer in Wisconsin here. It made the news. Somebody drove off the road, through her yard, through her shed, and into her kitchen. and he claimed to not have had any sort of medical condition. But illness without forewarning used to be a form of sudden emergency, so that they could defend themselves by saying, well, sorry, I had a stroke. Well, what's happened in Colorado now, and this is actually good, is they've abolished sudden emergency, and it's all been subsumed within comparative fault. So now we have to show that, well, yeah, okay, something may have flown off the trailer ahead of you, but you didn't have to swerve into the right lane. The tire was nowhere near you. All you had to do was gently apply your brakes, and everything would have been fine. You overreacted, you panicked, and that's not what a reasonable person should have done. Grandpa drives off the road and through my sister's kitchen and argues, well, I had a stroke or I had a seizure. Well, okay, but you've had 12 seizures in the last 18 months. You shouldn't be driving. You drove knowing that this possibly could have happened. You're negligent, and the jury has to take that into consideration. Seatbelt defense. You know, the argument that a plaintiff shouldn't be able to recover all of his damages if he wasn't wearing his seatbelt is a defense that's used in a lot of states. We have a chart, by the way, on our website that covers this in all 50 states. Seatbelt use is required by law in Colorado unless you have here's what it says. For this statute to apply, somebody having a psychological disagreement with seatbelts does not have to wear a seatbelt. You know, I've often wondered what that means, but anyway, seatbelts required. Failure to use a seatbelt is admissible in a court of law to mitigate damages. It's up to the jury to determine. A lot of times experts are involved, but in Colorado, it's limited to awards for pain and suffering, and it may not be used for limiting recovery, economic loss, and medical payments. In other words, Medpay benefits, medical expenses, lost wages are not reduced, even though they find the plaintiff 50% at fault for not wearing a seatbelt. Guest statute, family purpose doctrine. You know, the guest statute is another fad like Nofault that went away in the 70s. Most states abolished their guest statute, which said you couldn't sue a family member that was driving in order to avoid collusion. Okay, there's no such thing. You can sue any family member in a vehicle if is a driver, passenger, etc. However, the family purpose doctrine is something we should use. This is a doctrine, they're in the minority, they still have a family purpose doctrine, known also as the family car doctrine, which says that the head of a household with control over a vehicle is vicariously liable if all of these things apply. The owner was the head of the household, had control of the vehicle used by a member of the household with the express or implied permission. The member of the household was negligent in operation, and this negligence causes damage. You don't have to have negligent entrustment, but if you have the head of a household, and I find in the year 2015 that I find it awful interesting what would qualify as the head of the household. I wouldn't want to be the lawyer who argues, well, no, it was mom who let him use the car. That doesn't qualify. Unfortunately, in my house, I don't have liability. My wife would have liability. Now, having said that, let's move on to dram shop cases. This is significant because they have a special dram shop statute. What is a dram? A dram, interestingly, is a pour of alcohol. It's a pour of alcohol that's determined only by the generosity of the pourer. And that term has come to mean any kind of tavern or even in some cases social host liability for serving alcohol. But Colorado recognized, it's funny, Colorado can be so liberal and so conservative in other situations. In this case, they take the conservative route, and they recognize that in certain situations, it's the consumption of alcohol, not the serving of it, that's the proximate cause of the injury. Okay, well, you know, that's a growing trend. The person selling liquor is only liable if he serves a habitual drunkard. Yeah, proving that and proving the head of the household can be a monumental task here, but if person selling liquor to a habitual drunkard can be liable only if the person is first put on written notice not to sell to a drunkard. So you guys want to set up some insurance claims, you send a letter to every tavern in town and say, don't serve my husband, and you then will have a claim. Any social host liability only if there's willful and knowing service to a person under age 21. So if the kids get together and serve out of your household and you were just careless, No social host liability applies as it does in some states, only if you're willfully and knowingly serving those minors. I want to just tell you that we have a winner of our trivia contest, Victoria Ellis, California Casualty Insurance Company. Congratulations, Victoria. We're going to send you a copy of the book, Automobile Insurance Subrogation in all 50 states. Awesome. Good job. Go through statute of limitations real quick. Personal injury is 2 years. If an auto is involved, 3 years. Remember that. This is an auto subrogation webinar. If an auto is involved, you have 3 years for property damage or for personal injury rather in Medpay situations. Property damage is 2 years. Uninsured motorist, 3 years from settlement or judgment between the insured and the uninsured motorist. Uninsured motorist subrogation, 3 years from the date of the UM payment. This one up here, the third bullet point should be underinsured motorist subrogation. My apologies. And lastly, product liability is 2 years. Recovery of costs and attorney fees. I did want to mention this because this is a tool that we can use. It used to be that offers of judgment were used in California. That's now gone. An offer of judgment was a settlement offer submitted by a defendant to a plaintiff. And they took away Rule 68, the offer of judgment. And now Section 1317-202, known as an offer of settlement, applies to both plaintiff's offers and defense offers. So under this statute, you can see if more than 14 days before trial, we make a settlement demand on the defendant and the offer isn't accepted, and if we receive a more favorable amount of trial, then the plaintiff is awarded actual costs that accrued after the date, and there's the costs right there that you can recover. No attorney's fees, unfortunately, but use this. When you make a settlement demand, a subrogation demand, make a demand if you need to. If it's going to be a difficult case, you've got a substandard, non-standard carrier involved, make a demand, $25 less than the full amount, and that puts some pressure on them. Conflicts of laws, this is a complicated situation, but when you have a vehicle traveling from one state to another, Colorado applies the most significant relationship test, which basically says that the following principles are taken into account, and then the court determines which state has the most significant relationship to the accident and the damages involved, and they apply the law of that state. So if you drive from California to another state that allows Medpay subrogation, the issue is, well, can you subrogate your Medpay payments in Oklahoma or someplace where that's allowed? And the answer is there is no pat answer, unfortunately. This is the most common question we get, and it's going to depend on those items. So I'm a little bit over, and I see I have a lot of questions that are coming in, and I want to address some of those. Again, if I don't get to your questions, I would invite you to forward those by email to Jamie or to me. If you go on our website, there's a subrogation question feature there, located amazingly conveniently close to the refer a file button. And you can ask any question that's subrogation related, and unless it involves me giving you some legal advice outside of the attorney-client relationship, you will get a response from either myself or one of our attorneys answering your question in short order. And we do spend a good part of our day responding to those, so it's very, very heavily used. All right, question one. Don in Fort Myers, Florida asks, can I subrogate dealerships' collision payment for accident caused by customer test driving vehicle? All right, so can the dealerships auto garage keeper auto policy that pays for collision damage to a new car that's being test driven by a potential buyer of that vehicle subrogate against the permissive user? In Colorado, when a permissive user is test driving a car, Colorado takes a rather restrictive approach. Neither the dealership nor the carrier can subrogate against a permissive user. They say, unlike most states who may have a different reason for this, they say it's against public policy. And they held that even when the dealership has a clause that denies coverage to the permissive user so that they're not considered to be a co-insured, and they're not violating the anti-subrogation rule of subrogating against your own insured. It's not allowed because it's against public policy. So that's the answer to that question. Beverly in Los Angeles. I have a collateral case in which $25,000 limits are available, but there are 3 seriously injured plaintiffs, and I have a $22,000 auto property damage claim. Can I race the other plaintiffs to get the limits? Okay, so $25,000 limits, $22,000 auto property damage claim. Can the subrogated collision carrier race the 3 paraplegics to get the $25,000 limits? There are no cases in Colorado which discuss priority of paying multiple claims. There are no cases which discuss the duty owed by a liability carrier with regard to minimum limits when facing multiple liability claims. I will just say that I know every contract contains an implied duty of good faith and fair dealing. Violating that gives rise to a claim for breach of contract. I don't know of any cases where that happened. But whether or not a party acts in good faith is a fact question that depends on the facts of the individual case that's involved. I would encourage the liability carrier in a case like that to interplead those amounts, but interpleader is allowed and encouraged in Colorado, but there are no cases that say, as there are in many states, yes, you can. The first one to the money gets the money, unfortunately. Okay, Ron. Ron in Detroit. Ron asks, wait a second. Yes, Ron asks, an auto property subrogation claim in which our vendor did not make a demand on or have a subrogation suit filed until 33 months after the auto accident. I have an auto property subrogation claim in which our vendor did not make a demand on or have a subrogation suit filed until 33 months after the accident. Oops. Are we barred, or does the statute run from the date of the collision payment? It is a single vehicle accident and involves a potential crashworthiness case. Roof caved in simple rollover. Well, a couple of things. Remember the economic loss doctrine. We may be able to subrogate for property damage to the vehicle if it's a product liability case against the manufacturer, unlike most states. So that's good for you. Personal property statute of limitations is 2 years, except those based on strict liability. So no, I would say that okay. 33, how much is 33 months is almost 3 years. So it's not quite 3 years, over 2 years. Remember section 1380-101, there's a 3-year statute if motor vehicle is involved. If the action involves the use of an automobile or any tort action for bodily injury or property damage arising out of the use of a motor vehicle, the claim can be brought within 3 years of the date of the cause of action. So I think you're good in that case. I think your vendor just avoided a bad faith claim there, or a malpractice claim. So tell them they can sleep better tonight. Next question. Tom in Rhode Island. What about a case where Medpay benefits under Utah policy are paid and the Utah insured is involved in an accident in Colorado? I'm going to send you an email on that just because that involves the most significant relationship test. I just said, and I'm going to need to know more about the facts to know where the car is garaged, where the insured lives, where the contract was entered into. There's a lot of factors that I would need to look at on that. Okay, lastly, well, not lastly, this is the last one I'm going to cover, and then I've got several coming in here that I will respond to via email. Question. This is Robert in Oklahoma City. If a claimant has minimum limits, but the owner of the vehicle has more insurance, but loaned the vehicle to the driver knowing he had a suspended license, can I recover against the owner and the driver? I will tell you that I'm always confused by the word claimant. A claimant means somebody who's making a claim. So I think what you're saying is if a defendant if a tortfeasor has minimum limits, but the owner of the vehicle has more insurance, and loan the vehicle to the driver knowing he had a suspended license okay, so negligent entrustment. Yeah, Colorado negligent entrustment is alive and well. The elements include you have to have a duty owed by the defendant to the plaintiff, a breach of that duty. You have to have injury to the plaintiff, the insured, and there has to be approximate cause between the breach of the duty and the injury. Colorado follows Section 308 of the Restatement of Torts, which concerns negligent entrustment, and it reads as follows. In fact, I'm going to open the book. I'm going to open the Bible and read right from it here. It says, Section 308, it is negligence to permit a third person to use a thing or to engage in an activity which is under the control of the actor if the actor knows or should know that such person intends or is likely to use the thing or conduct himself in the activity in such a manner as to create an unreasonable risk of harm to others. Case law does exist that says if you are lending a vehicle to someone who has a suspended license, you can be held liable for negligent entrustment and recover damages. But the key here in negligent entrustment cases is the driver with the suspended license has to be at fault. Otherwise, you're not going to be able to hold the owner at fault, because that's the whole purpose of negligent entrustment, is to avoid him giving a vehicle to someone who's obviously negligent, and if they're not negligent, the negligent entrustment won't follow. So that concludes our webinar today. I want to thank you all for attending. By the way, we had 374 people attend, and that includes a number of conference rooms. We appreciate the wonderful attendance. The next webinar that we're going to have in this series on automobile insurance subrogation will be the state of New Jersey. New Jersey is number 7 in the list of auto webinar series. So have a great day, and we'll talk to you soon. Bye-bye.